Hi everyone, Joe Kral, President of the Society of St. Sebastian, and again, welcome to Pro-Life University. We're going to do some things a little different this week. Obviously, the March for Life is on Friday, and a lot of stuff is going on with respect to the 47th anniversary of Roe v. Wade. A lot of interesting sort of things happened this week, and before I jump into our topic, and our topic is really going to talk about some of the problems that we see with Roe v. Wade, some of the things that the justices should really have looked at. But before we jump into that, I just want to congratulate again our academic fellows, our public policy fellows, and our fellows for the Society of St. Sebastian, which were just named this past Monday. January 20th is the feast day for St. Sebastian in Roman Catholicism. It's December 18th for Eastern Catholicism. But January 20th is the day that we announce all these fellows, and I just want to say congratulations again to those wonderful folks that got a much-deserved honor for helping push forward the pro-life movement intellectually and through legislative action. Thank you so much for what all of you have done. We appreciate it at the Society, and obviously all pro-life advocates out there appreciate what you're doing to help establish a culture of life. Okay, now that we've said that, let's jump in to what we have to say about Roe v. Wade and some of the problems that I was just mentioning just a few minutes ago. As we know, Roe v. Wade was decided, or rather, the decision came down 47 years ago. But there's a case, interestingly enough, that happened several years beforehand called Griswold v. Connecticut that really was kind of the basis of Roe v. Wade, that set up this idea of a right to privacy as a penumbra under the Constitution. And this Griswold v. Connecticut basically legalized contraception to unmarried couples. Several states had made it illegal to sell to contraception or to unmarried couples. There was all sorts of laws going on there with respect to that. But Griswold v. Connecticut basically legalized contraception for everybody, for any reason, anytime. And so, basically, in many respects, we can see why, especially as Catholics and as many Christians also believe, that we can see contraception working hand in hand with abortion. They both sort of have kind of an anti-life mentality. Contraception, obviously, against conception in many ways. It kind of lends a hand, if you will, to this philosophy that, I don't have to have a child if I don't want to, and this whole idea of abortion. But there's obviously some philosophical differences between the two. And I'm not going to so much get into that right now, but suffice it to say, this Supreme Court decision that was handed down in the 60s laid the groundwork, if you will, for Roe v. Wade, which was decided in 1973. Now, let me just simply say this. Now, we're all familiar enough with Roe v. Wade and Doe v. Bolton and what the justices had to say. Many of them refused, for example, to recognize that this was a person. They didn't want to answer that question. All they basically said was, well, we think that the framers, when they were framing the 14th Amendment, were only speaking of persons postnatally. And so up springs this so-called right to have an abortion, if you will. And again, I think that's highly problematic. And I think most of us would say that. As pro-lifers, many of us it's obvious that the unborn child, whether that unborn child be at its earliest stage of development, such as a one-cell stage zygote, or if it's on the brink of being born, still an unborn person, still deserves respect under the law, and so forth. For us, it's very obvious. But what went wrong with the Supreme Court here? And I think in many ways, from an ethical framework, we can definitively see how they violate what's called the principle of the safer course, all right? It's the idea that you err on the side of caution. We typically do this in everyday sorts of things. We err on the side of caution. If we don't think we should be doing something, then we ought not do it, right? And here we certainly see this. Now, they said, well, we're not going to answer this question if the unborn child is a person or not. So we're going to allow this right anyway. Well, it's a grievous violation of this principle because why? Well, if you're not sure if it's a person or not, or if you're not sure if it's a constitutional person or not, you should err on the side of caution. What do we mean by this? What do I mean by this sort of thing? Basically this, that if you're not sure if it's a person, you should not allow for the killing of that at bare minimum, what they would refer to as a potential person. I think that's highly problematic because here we can see the sort of dilemma that arrives. All right, on one hand, it may not be a person. On the other hand, it is a person. Now, if it is a person and you allow for abortion, then you're obviously sanctioning legalized murder, right? The unjust killing of innocent human life. Well, that's why they should have erred on the side of caution. That's why they should have followed the principle of the safer course. If they weren't sure, they should have said, we can't answer that question, but we want to be safer rather than sorry. And so, we're not going to say that this is a constitutional right, if you will. Which obviously gets into the subject of rights in general, right? And I think to some extent we need to recognize, especially this idea of natural rights. So for example, the founding fathers talked about life, liberty, and the pursuit of happiness, right? In the Declaration of Independence. Well, they're talking about those inalienable rights, right? Those are what we would refer to as natural rights. Those are natural rights to us. They're not beholden to any government. No law sets them, so to speak. They're naturally there because of what we are. And what we are human beings, right? And so we have to understand that when we get into the ethics of rights, the most fundamental thing that we need to know is that rights extend from our moral duties. Right? That's how we get rights. That's where rights are derived from. That's where these natural rights are derived from. So, when we talk about the right to life, for example, right, which is a natural right, we talk about how we have a right to life. Well, it's because I and other people out there, everyone out there, as a matter of fact, have the duty not to harm or kill innocent human life. Very important. Right? This is an absolute moral duty that's universal to every human being, right? And because of this duty, we derive a right to life, right? We derive the right not to be harmed unjustly and so forth. And so, in many ways, the law is supposed to protect that right, if you will. And so that's why you have laws, for example, that prohibit murder or negligent homicide or manslaughter and so forth. We recognize that we have a moral duty not to kill other people, right? Very important to understand that here. And that's something else that the U.S. Supreme Court sort of kind of threw out, if you will, with the bathwater. They literally threw out the baby with the bathwater in this instance, which is obviously a huge tragedy, given how many children have been killed because of abortion throughout the years, for the past 47 years. The simple truth of it is since the U.S. Supreme Court kind of failed, if you will, in recognize what a right really is, and two, didn't want to define the person and didn't want to follow the safer course, right? And since they did these really extreme, unethical sort of things, if you will, we can see why it's had such a hardship and it's been such a tragedy within our own society. There's a reason why, people are beginning to devalue life more and more. It's because there are laws out there that directly devalue life. abortion is obviously a prime example of this. And if we can't expect to respect and do what we ought to do our moral duties and have, their rights protected under the law, if we can do whatever we want to vulnerable human life, people aren't going to respect human life in general. And we got to understand that law is, as a great teacher, is meant to show us the value of life, the greatness of life, the richness of life, the gift of life. And so, on this anniversary, this whole week, and even if you're out there marching at the March for Life in D.C., or if you're at your local March for Life in your own state, think about this. Contemplate it while you're marching. Life is a gift. Life ought to be respected. That's why, under natural law ethics, we have such a tremendous respect for human life. Life is something that is sacred. We recognize our moral duties. We have the capability of recognizing our moral duties. And law has the obligation to reflect the natural law. And in this case, obviously, that didn't happen. And as a result, we now see the tragedy. Again, thank you so much for what everyone does out there. Thank you for our fellows. Thank you for going out there and marching for life. Remember, always urge people to choose life. I'm wearing my favorite tie, as you can see. Hey, thumbs up there. And go out there and make a stand for life. We're seeing more and more that people are going out and they are ready for this year. They are ready for this year to pass more pro-life legislation, to elect pro-life leaders into office. And let's go out. Let's really trailblaze this upcoming year and really help try to establish a wonderful culture of life that future generations can be born into, so they can experience a true richness of life and appreciation for human life at all its various stages. Again, God bless, and I hope this was informative. If you have any questions, don't hesitate to comment below in the comments section. And again, I hope you all have a fabulous weekend. I hope you have a fabulous March. Go out there and let's march for life. God bless.